Good morning, ladies and gentlemen. Welcome back to Paralegal Counseling Training. This is your host and your tutor, Dr. Tripo Wenfumbo. We continue on the course entitled Paralegal Practice and Counseling. We are looking at Unit 4. Unit 4A, which we are talking about mediation skills. One of the major works of the paralegal counselor is conducting mediation and attribution. Often other independent people can help with negotiations, especially if the two conflicting sides or conflicting parties cannot each reach an agreement on the problem. One party might also believe that it has compromised enough and now the other party must compromise. So in the situation where people fails to agree on certain things that they want to agree on, there is a need for mediators. For example, when there is debt issues, or maybe this one feels he has been charged more on the interest. So in such a case, there is the need of a mediator. So as a paralegal counselor, you are also trained to be a mediator or attributor in cases whereby you need to sit the parties together and come up with the solution which is going to favor both of them. So a third party can come in as a mediator, and that is we are talking about here we are talking about the paralegal counselor or an attributor. If both parties agree that a mediator or attributor can help them to resolve their problem, then they can invite someone to act as a mediator or attributor. Both parties must agree who the mediator or attributor will be. Formal legal mediation and attribution process are used in resolving labor disputes and other conflicts. You know, the attribution or mediation is one of the way of resolving matters, what is called conflict resolution. So in the resolution of matters, sometimes it is very important that as a paralegal counselor, you just need to sit people together instead or before you even do the lawsuits, because that may be cheaper, and also it may help in reducing the costs, the legal costs. So as a paralegal counselor, you may advise the party or one party for mediation. And that is mostly what the court does in civil matters. In the civil matters, before the magistrate or especially the judge begins the sessions with the court sessions, first he would seek the plaintiff and also the defendant to go for mediation. And if they fail to come up with a resolution whereby they fail to agree on certain matters, that's when now the judge comes to hear the cases and makes a decision to who the matter favors. So what is the duty of a mediator? The main job of a mediator is to keep the parties in the negotiation communicating with each other. To do this, the mediator must get the trust and confidence of both parties and keep this trust by always being objective. So as a mediator, you should not take sides. So if the one way of being an effective mediator is to be trusted by both sides. Both sides should know that you are not there to favor anybody, or you are not there to side anybody, but you as a mediator, you are there to ensure that to ensure that the parties are getting what they are supposed to get, or they get the fair mediation. So the mediator must try and find out exactly what the problem or conflict is about. When the two sides meet together, the mediator must encourage both sides to be realistic about what they want from the other side. The mediator must keep things going and create confidence in both sides so that they will be able to resolve the conflict. So, as a mediator, you are there to stand in between. And one of the things that you are supposed to do is to assure the both sides that you are there to resolve the matters. And that is when you are introducing yourself as a mediator, first you have to tell them, my name is Tulipo Mwenfumbo, and I feel these are my qualifications. I'm the mediator, and my duty as a mediator is not to cite anybody or not to cite any party. So as we come here, we need to be open-minded, and we need to know that I'm not citing anyone. So can you trust me to mediate on this matter? Then the parties are going to answer, and when they answer yes, we trust that you can mediate this matter, then as a mediator you are going to mediate it well. So the mediator must keep things going, ensure that you give time for each party to explain about their parties. And one of the things that you should tell them is that the parties must be willing to express what they feel and how they feel about the matter. The mediator does not make a decision about who is right and who is wrong. A mediator does not act like a judge. The mediator goes on assisting both sides until the parties themselves come to an agreement. If it is clear that the parties are not going to reach an agreement, then the mediator might have to withdraw from the process. Now, as a mediator, you are not the judge. You are not there to see who is doing right and who is doing wrong, who is right and who is wrong. As a mediator, your duty is to stand in between and to make sure that this person expresses his view and this person expresses his view, and you ask them question. What do you think about this? Where do you think is this fair to you, or don't you think that if this matter can be resolved in this way, it can be better for both of you? So you are trying to bring the both parties into a matter whereby they are able to agree. And if the parties could not agree, as a mediator, don't be judgmental. Just say, since you cannot agree on this matter, I think as a mediator, or my hands are tied, and I would recommend that you go to the courts of law, and the aggrieved may go and sue the party. Then the parties must find another way to resolve their conflict. For example, attribution or going to court. If you are representing a person or group at a mediation, then you need to prepare for the mediation in the same way as for negotiation. So in mediation, you need to prepare yourself as a mediator, and you have to ensure that both parties feel at home and they feel confidence on you. Attribution. The attributor is like a judge. The attributor chairs hearing at which both parties are present, listens carefully to both sides of the story, listens to any witness, and looks at any document which might be produced as evidence. So the difference between a mediator and an attributor works like a judge. So as an attributor, you want to be fair in the way you look at things. So you invite these parties, and also you tell them to bring the evidence on why the matters is being why they feel that matter should be judged in a certain way. At the end of the hearing, the attributor goes through all the evidence and decide who wins the attribution. That is whereby you are going to give the facts why this person should be favored in one way or another, or why the other party should be able to cite or to hear the other party's view. So you look at the evidence and you should be able to bring out the reasons enough, and you should bring out what this person said and the evidence that they brought and the other person. Then you have to make a decision and say, I think in this regard, I feel that so you can it will be fair that I feel it will be fair that this is given to this one. So the attributor writes down the reasons for his or her decision and gives them to the parties. The decision of the attributor is final. So the parties must obey this decision. You cannot appeal against the attributor's decision if you think that he or she did not interpret the facts correctly. You can only appeal on grounds of fraud or corruption. This is I want to bring to you the issues of small claims court. The small claims court works with attributors, and in this regards, you cannot make an appeal. So what you do is to sue the case. You should just restart the case to the courts. So the attributor should use proper legal principles to interpret the evidence, but an attribution needs not be a formal legal process, such as a proper court case, and the parties in the attribution are not represented by lawyers. Now, there are issues that will need attribution. There are matters that will need attribution, and these are the matters that you as a paralegal, you can attribute or you can be able to mediate, like the matters of consumer complaints. If the consumers are complaining about the matter, maybe someone got something that is expired from the shop, and the shop owner is refusing to refund this person. So you as a mediator, you'll be able to help these people to bring about the facts why they feel it's supposed to be done in the way each one feels. The community or neighborhood. So you can also do the mediation when there are conflicts in the community or the neighborhood. There are misunderstanding in the neighborhood. Also, there are criminal courts. There are criminal matters like assault. Assault may be both a civil or a criminal matter. So in that case, for example, this one is claiming, I need this one to pay me 10,000, and this one said, no, I cannot pay you 10,000 on the assault cases. On the assault case, then you bring them together and you'll be able to mediate. Why do you think you are charging this 10,000? And you ask, why are you refusing? Don't you think this 10,000 is not fair? Or don't you think that 10,000 it is fair? So both parties, they'll be able to listen to each other as view, and they'll be able to use empathy to each other and be able to view the matter on the other side's perspective. The other thing that needs mediation is education. For example, there is a difference between the school and the administration and the students. This also needs some mediation. Like we have heard most cases where the school union and the administration differs on the certain matter. And also we have heard where the students, the student and the teacher have the difference. So you can be able to mediate in those matters. The other matter that you can mediate is family matters. When there is difference between the parents and the children, there is a difference between the aunties and the uncles, the nieces, nephews, and all the differences that may occur in the family. You can work as a mediator, and also in the matters of divorce. You can be able to mediate such matters. The other matter that you can be called for mediation as a mediator is the environmental matters. Maybe there is this compound that wants to build something in that compound, and the compound or the community refuses on that. So you are able to mediate. Or maybe there is a matter whereby there is someone who has maybe there is like these issues of illegal settlements. So in such cases, you can be able to mediate and help the community and also the parties to come up at the place. Can this place or can this land be sold? Now, if the owner of the land said, I cannot sell the land, now you have to look at what methods, what better methods can be helped to resolve the matter. Thank you so much, and God bless you. And let's meet in the next class when we shall continue looking at the mediation and some of the issues that some of the facts that you have to look into as a mediator. Thank you so much, and God bless you.